Afternoon, Marylanders, and especially every gun owner and constitutionalists around America. I haven't seen any comments about the Young versus Hawaii case, but I wanted to make some of my backseat driving comments because there were some things that I thought that was interesting here. So first of all, I'm gonna give the bad news first, then I'm gonna give the good news of what I saw. But I'm gonna be blunt with y'all here. One of the things that this was interesting. I was talking to a guy. For Marylanders, where this as we know that President Trump is going to be appointing a new Supreme Court justice shortly, and this will definitely change the makeup of the court. And this will probably be one of the next few possible carry cases to reach the Supreme Court level. And there's also a NYSERPA versus Beach in the Second Circuit. If they choose to bring it up to the Supreme Court, I believe they should. Um, there's also Whalen versus Handgun Permit Review Board in the state of Maryland, and that they could bring that up through the Special Court of Appeals. I believe they should as well, and then bring it through the Maryland Supreme Court, then to the Supreme Court. There's also a couple of carry cases out of California. Edmund, I want to say CaliforniaOpenCarry.com. Please show him some support. I will link his videos or channel in the description because he is doing this pro se, which means by himself. And now to go into the meat and potatoes of Young versus Hawaii. This is basically the judges, depending on what their bias is or how they are viewing this, or whether they are pro 2A or anti 2A. It's going to be a fight between may issue, because legally Hawaii is a may issue state. They can grant permits, but policy wise, they just don't. And one of the major issues, or major, I want to say that major no-nos, I want to say that it almost sounded like the counsel for Young kind of conceded, and he by saying that Young would be totally fine if he received a permit to conceal carry or open carry. I believe he should have just stuck with open carry only, because concealed carry has already been beaten to a dead horse in the Ninth Circuit Court of Appeals. So he should have just stuck with open carry only. The second big issue is that I'm gonna be honest, the way he approached this was actually pretty well, but also he didn't approach this. He approached this as the Ninth Circuit en banc, how they have had precedent. As far as trying to, he kind of shot down intermediate scrutiny as far as having certain ways, alternative methods to carry. So he was appealing to the court through Ninth Circuit precedent, how they have used in previous cases. The counsel for Hawaii, they have a new lawyer. He actually did a number on arguing the perspective from text, history, and tradition. And I'm be honest, it did sound very appealing from Hawaii's side. But one thing he kind of deceived the courts with, which I was hoping that Young counsel was going to point out, is that he kept saying is that May issue was a long standing tradition in the 20th century, which was not necessarily true. The thing about May issue is that it was May issue, yes, for concealed carry, and they have already determined that concealed carry was outside the scope of the Second Amendment. Yes, some states did have May issue clauses for concealed and open carry. If you go to Iowa, I believe, or Minnesota, you would have to have a permit to conceal or open carry, and their legislators brought it to a shall issue. But a lot of in the 1800s, historically, text history and tradition wise, is that states did try banning open and concealed carry, and the courts was like, you're not going to ban open carry. You can regulate concealed carry because they just the way things were. Concealed carry was not seen as a historical right. So to say that that May issue was a thing, yes, it was a common thing for many of the states, but not for open carry per se. So that was one of the main things I wanted to bring out as a long-standing tradition that he kind of deceived the court. The main thing that I saw good out of this is that, and I'm not even want to say it's good or bad, but a lot of the silence from the judges was actually very telling. Like they didn't want to rip into the case often. To be honest, they didn't say a lot. They could have pressured him just like they did in the three circuit panel, because of the simple fact they want to keep harping that it is a complete licensing scheme. Yes, legally, but no permits have been issued to private citizens. So what do they do about that? The last dissenting opinion from the three panel judge basically just didn't even speak about it at all. Like, they didn't even care about the fact that there was no permits issued. So if he loses this case, if Hawaii loses this case, or excuse me, if Young loses this case, there will actually be some good that might come out of this, because if he loses this case, I believe that the judges are going to say is that this is a may issue statute, just like all of the other states. You got the First Circuit and Pachowski, you got the Second Circuit and gosh, I forget the name, Filco, third, and Drake, and fourth and Woolard. So, and DC shot down their may issue clause, and Wren shot down their no issue clause. So that leaves basically Hawaii as last. And then technically, there are actually, believe it or not, there are actually a ban. Their pistols are actually banned in America Samoa, and Northern Mariana Islands is a no issue state. I don't even know how they're able to get away with all that stuff, but that's it. That's a separate, different topic. But if they lose, and if the judges say that this is because of a may issue statute, they are not. Hawaii is not going to be able to moot this case as simple as NYSERPA versus New York City was able to do by simply issuing Young a permit to carry, because it won't be about a policy issue, which made it a no issue jurisdiction. They should have just it would be a may issue, and they won't be able to simply plop that out in the law. Now, one thing also I do want to bring up that Hawaii Council did really good is that it wasn't the fact that Heller made the point of the core issue of being able to keep and bear arms. He said they specifically wrote the core issue is self-defense, and there are no other alternatives to be able to reasonably do that in the state of Hawaii. They banned tasers. I believe you have to have a permit in order to carry long guns, which I don't. It's kind of weird about that. I'm not even sure how that do. They don't issue handgun carry permits unless you're security. So there's the right to self-defense has been eviscerated. The judges will literally have to chop up Heller in order to have Hawaii come out with a win with that. But I'm praying that it's not going to matter at that point, as President Trump will be able to put one additional member on the court and relieve Roberts of his duty to be able to be kind of like the center focal of a balanced court of nonpartisan. That's basically what happened. Scalia, Big Daddy Scalia died, and rest his soul. And now Roberts is the one that's truly taken over. And especially with the Heller decision, it would all be on him. And he doesn't want this court to look bad, because he was worried that the Democrats would pack the court, or, he's worried about his image, whatever. I don't think he's, corrupt as he's working with like certain parties enough. I just believe he's more caring about the court's image, and, wherever his legacy is going to be led. It's less about constitutional issues. But that's another topic. But now with the new member, hopefully it'll be Amy Coney Barrett. We know that she has been more fervent on Second Amendment policies. We don't know too much about any of the other choices, but hopefully this will be able to settle this case once and for all. I know, Maryland is a may issue state. There's Maryland, New Jersey, Hawaii, Massachusetts, California, and there's like three other ones. There's Rhode Island, a couple other ones. But this May issue is very discriminatory. And I actually gave a case about how Maryland's one started. It was actually started to discriminate against. They sent not just the May issue clause, but also stop and frisk. And it didn't affect the whites in the suburbs area. It actually affected the blacks in the cities. They were just, they passed the bill in Maryland overnight, and basically if you were found with a pistol on you, you was deemed a criminal. It could be a misdemeanor up to 3 years in Maryland. So that's all I wanted to talk about. Please leave a like, share, or comment in the description, or and let me know what you think about it. If I'm wrong about anything, please correct me. Thank you very much. Have a good one. Bye.